topic, but every corporate or every professional who runs and participate in corporate should know, especially the sales team, especially the people, those who are not the legal side of the profession, but business side of the profession, they also. So topic is competition law essentials, what every business must know. Friends, we have not selected a specific topic of cartelization and other thing, but we have selected this topic. There is a reason. Today, what is happening, CCI is becoming active and they are doing lots of investigations. They are asking various questions. They have given the provision of law that you have to follow this. And then you must do what the law is saying. So this competition law is playing a very critical role in shaping fair market and responsible business conduct. Now, this business conduct word is very, very important. With increasing regulatory scrutiny, active enforcement, and evolving market practices, all business across all sectors must understand how competition law affect their business, pricing, strategy, collaboration, market size, distribution model, merger, joint venture, and daily commercial decisions. Now, after the evolution of digital business or e-commerce business, it is becoming a more and more important and more risky for business when they are doing this type of thing. So today's webinar, we aim to provide a practical and business-oriented overview of competition law, focusing on common regulatory risk, frequently encountered violations, and expectation of regulator such as Competition Commission. Though real-world example and enforcement trained, the session will help business identify red flags, manage regulatory risk, and embedded competition law principle into corporate governance framework. So all the practical issues, all the practical questions, all the practical aspects we want to discuss in this webinar. So key discussion point for this webinar is competition law framework for business. That is one part. Second is agreement, which can be anti-competitive common business risk. Then we have an abuse of dominance, understanding market power. Then we have a merger control and combination regulation. Then we have a practical takeaways for business. So these are the topics which we want to discuss under this topic. And I extend a very warm welcome to our learned panelists who, when I will introduce, you will realize that they are walking, talking, and eating competition law. And their background, their past knowledge is tremendous. So I first welcome Mr. Dhanendra Kumar, who is a distinguished Indian civil service servant and expert in competition policy. A unique feature is that he is a 1968 batch IAS officer, Haryana cadre. He served as a first chairperson of Competition Commission of India, CCI. So when I emphasizing first mean that whatever law has evolved, whatever base has created, it has done during his tenure. So he has laying the foundation for India's competition law enforcement framework. He also represented India as executive director at World Bank. During his career, he held various senior positions, including Secretary in Ministry of Defense, Road Transport, Highway and Cultural. And after the post-retirement, he has chaired expert committees on competition and regulatory reforms and continue to advise on policy and governance matter through his company, which is Competition Advisory LLP, which he is providing since 2012 after the retirement. So you can understand his knowledge, his expertise in wide area and international exposure in World Bank. Today, we will learn from him lots of good things which will enhance our knowledge about the competition law. I welcome you, sir, for this program. Then we have invited Mr. Manish Mohan Gobil. He is serving Indian Revenue Services Custom and Indirect Tax Officer and currently serving as Principal Commissioner CGST Delhi North since October 2023. He's IRS officer. Now, the interestingly, Manish has done various area and as a leadership role in customs, CBIC, DOPT, DRPG, DGGI, NACEN, and he was advisor to Competition Commission on deputation. And that time at CCI, he led advocacy, legal and combination, handled 400 plus M&A cases and driving case ease of doing business reforms with over 25 years experience. He is a Finance Ministry Awardee 2017, published author on competition law and alumnus of SRCC, Delhi University Law and IDS Ministry University of Sussex. So Manish has wide experience like Dhanendra sir has. He is on the financial side. He has done work in taxation, custom and other thing. And during his period, we have interacted with him. We have invited, we have heard about his mastery on the subject was superb. So I welcome Manish. He is joining. He is in a meeting with the Revenue Secretary. He will join shortly. Then I welcome Mr. G.R. Bhatia. Mr. Bhatia is a senior partner and head of competition law practice at Corporate Professional with over 30 years of experience in competition and regulatory law. A former additional director general at Competition Commission of India and MRTPC Commission. He has received international training in Japan, South Korea, and contributed to the 2007 amendment to the Competition Act, appointed expert by the Ministry of Corporate Affairs. He regularly appears before the NCLAT and the Supreme Court of India and a consistently top-ranked competition lawyer in India. And I will tell you about Mr. Bhatia. He has worked in MRTPC also, which is the CCI is the output of that particular thing. It's a fine version. And Mr. Bhatia has taught us the MRTPC law and the competition law also. And we remember so many cases which he has given, and I will use it during his training session. And today your student will tell you about the example, sir, which you have given to us. And we will definitely communicate to the participant that what is the issue and how to handle this. Then we have our last speaker, Ms. Vatsala Pandey. She is Senior Associate, Competition Law Practice, Corporate Professional. Vatsala is a lawyer and she is doing practice. And the interesting part is she's doing law practice, but her interest is more on the competition law side. So she has done a lot of work in this. So we will see today her performance on this discussion. So friends, these are our panelists. And you can understand one is the first chairman, not first CCI chairman, Mr. Bhatia, who was instrumental to draft all these things and doing practice. Sir is also doing practice. And then Manish Mohan, who was also in CCI, and Vatsala, she's doing practice in this. So we have a lawmaker also, and we have a practitioner also, and practitioner turns, lawmaker turns practitioner. That is a deadly combination. So Dhanendra sir and Bhatia sir is like this. So before starting this session, there was a curiosity when we were organizing this program. So some of the people have asked us that please tell us a simple word that what is CCI and how it is affected to me. So I have discussed with Mr. Bhatia and Vatsala, and I created one initial document. And the document is an introduction document. So the program structure should set in such a manner. Now, friends, competition law is not about the law. It is about business behavior. That is very important. So if you think that I'm talking the law is there, but behavior is very, very important. Sometimes you're doing legally, but your behavior become arrogant or you want to control something, it is the starting of violation of competition law. So today, no company, whether it's a small or too large, to be outside the radar of competition regulator. Whether you are fixing price, offering documents, entering a distribution agreement, forming a joint venture, acquiring a competition, suppose you want to acquire somebody, or simply becoming very successful, competition law will follow. Last point is very serious. Success is always celebrated, but here the law is watching you, so you should be very, very careful. Now, why this topic is critical today? India's market structure has changed dramatically. We have digital platform, network-based dominance, e-commerce ecosystem, data-driven pricing, cross-border mergers, startup acquisition. All these things are taking place in new age system. So every time growth is welcome, that is a one fundamental point. But pointed dominance without discipline attract scrutiny, and that is not allowed. Many companies do not violate competition law intentionally. They violate it because they follow industry practice blindly. So all the hoteler has combined together and they are saying, so let's raise 10% and make and then say this is a practice. But if you are doing individually increasing, but if you are collectively increasing in one dimension and one direction, it is anti-competition. They copy competition pricing behavior that he has done, so I will do. It's okay, you can do. But if you are combining and talking and then deciding and doing, it is wrong. They create exclusive arrangement that you will deal with me, but you will not do any other person. That is also. They impose resale price control. So many manufacturer is telling you have to sell at this price, not than this. So I have a margin. I can decide, I can reduce my margin, but they are saying, no, you have to sell on this. Then they underestimate their market power. Sometime that is also happening. And suddenly, when they are doing this type of thing, they receive competition commission notice and they are in, again, they surprise that why this particular thing, what I have done. So all these things when you are doing, so you should learn. Now, one, agreement can become anti-competitive. So you are doing day-to-day work. Even informal understanding between competitor can amount to cartelization. Simple example, let us not undercut each other. You are removing competition. Undercut mean you can give the less price mean to better to the investor or the people who will use this. You take North India, I'll take South India. That is also anti-competitive. Let us align a discount structure. That is also anti-competitive. These are serious violations. Abuse of dominance is about behavior, which I have told in the beginning, not size alone. So you just say that my size is small, so that's why it will not applicable. You may become dominant because you are efficient. That is not illegal at all. But once dominant, certain action become risky. Like I told you, the behavior. So when you say I'm commanding this particular area, you can unfair discriminatory price, you can increase the price. You can do the predatory pricing also. You can do exclusive supply agreement with people that lena ho lo, nahi to mat lo. Then they refusal to deal. They are saying I will deal with you, not you. You can decide. Bundling product to eliminate competitor. Then excessive pricing. All these things comes because of your behavior. So dominance brings responsibility. So you should understand we have linked जितने बड़े हो जाते हो उतना आपको थोड़ा नीचे होके बात करना चाहिए. But here when you are becoming big, you behave arrogantly, you behave differently, and anti-competitive way comes in business. Now when you are doing merger, you have to need planning. You have to see threshold analysis. You should market in impact evaluation. You see notification where required because law prescribed that if you are doing merger, you have to follow these filing. Sometimes business sign transaction documents and then realize filing is necessary, and then they file. So delay in action itself is becoming a violation. So that is happening in so many cases in M&A. Unintentional violation are common. You may offer aggressive rebate scheme, enter long-term exclusive distribution, create bundled discounts, acquire startup to remove competition without any malicious intention, but competition law evolved market effect. That is also very important, not intention alone. And that is also decided in so many cases that in competition law, intention is not whether it's a malified or not, or it's a something wrong. But doing this, market has impacted. That is also a violation. So that's why compliance check must be done before strategic decision. Growth must not become monopolistic behavior. We know success is celebrated, but if growth creates entry barrier or surpass competition unfairly, scrutiny increases. Corporate governance today must include competition audit, board level awareness, because when you are in the board and you are in the company, you must start competition audit, board level awareness, that board members should realize that what is, because today, as far as I concern, I know very few companies are doing the part of their information on competition law to the board. Transaction level review, training to the sales team, all these things you should do. India has business increasing CCI enforcement activity, higher penalty, strong focus on digital dominance, greater scrutiny of big tech e-commerce. The regulator is no longer reactive, it is proactive also. We have seen Competition Commission has put lot of penalty on various cases. Competition Commission versus cement cartel, where the CCI has put 6,000 crore rupees penalty, though these cases are pending in Supreme Court, but CCI has done this. Google LLC Android case, where they have paid 30, they charged 1,300 crore rupees. It is also in the Supreme Court. Flipkart Internet and Amazon sales, their investigation is going on, and various other cases are going on, which is part of the Supreme Court decision. Once the decision will come, all these things will be very, very clear. So these cases show the regulator is willing to examine traditional sector and digital market both. So I have shown you cement cartel is a traditional market and Google is a new age market. In international also, European Commission multi-billion euro penalties against big tech. United States Department of Justice aggressively antitrust action, and they have in XCOM mobile case, they have divided into two parts that company. Federal Trade Commission, digital market investigation they have done. So now India is also aligned with the digital market, data dominance evolution, ecosystem, and digital regulation things. Now, my last point is my message to the corporate leaders and the professional. Friends, all the people, those who are promoter, director, or board member, they must realize competition law is not filing formality. It's a post-facto legal defense or a technical compliance matter. It is a strategic risk discipline, governance responsibility, and board level conversation. If you are scaling fast, if you are entering exclusive contract, if you are merging, if you are acquiring, if you are offering dynamic pricing, if you are using algorithmic pricing, you must pause and ask, have we done the competition risk check? And Bhatia sir has taught us a case of Spain where the banana dominance was there. So it was how it has come, the toothless consumer. Who were these? The infant and the old age where they don't have teeth. So that company was dominating the banana dominance of and fulfilling these people. So that is also identified. So friends, in various cases also, in the DLF case also, that has happened, that they have control over Gurgaon, and that has come, and the CCI has put penalty of 535. But all these things are pending in Supreme Court. That decision will come. So have we done the competition risk check? That question should be asked by every board member. Now, message for legal and professional people. Your role is not to block business. Your role is design guards, identify red flags, train sales and marketing team, review agreement, and create internal reporting mechanism. So when you review agreement, you are seeing what are the losses to the company, but simultaneously you see what are the risk of competition also. Competition compliance must become culture, not crisis management. So you should not worry about, or you should not create the competition uh, area. When the notice is coming, you should make a part of this. So friends, competition law is not anti-growth. It is pro-fairness, and fair market creates sustainable growth for everyone. Today, you are doing something wrong, but tomorrow when you are going some other place, the same thing will apply to you also. So you should do this. So this is my entire discussion point. Before this, I just want to announce a very important thing, that we were doing competition and antitrust practice, but now we want to strengthen and expanding on this particular area of capabilities under the leadership of Mr. Bhatia, and we want to expand this in this. And then the very interestingly and importantly, we have Dhananjay Dhanendra sir, and we want to do the strategic collaboration with his company, corporate advisory, POAD, and we will do tie up with him, because he's doing his own practice, own company. But whatever we are doing, we will work with him also for various cases, various advisory, various opinion, so we can provide a very comprehensive and effective work to our clients, to the industry with this, so they can save the every part of this, and they can become the competitive competition law compliant organization. So with this, now I will request Dhanendra sir to start and tell us the journey, how this has, and what his experience of the industry, and what advice you want to give to industry and profession. Over to you, Dhananjay sir. Sir, you have to unmute, please.
Am I audible now?
Yes, sir. Yes, sir.
Thank you very much, Pavanji. I must compliment you and thank you, first of all, for a very generous introduction, and also for your 254th webinar. It has set up a new institution. Every Friday, we are holding a webinar, and we are lucky that this week it is on competition law. So, congratulations for this.
Thank you, sir.
So I must also compliment Mr. G.R. Bhatia for heading this competition law practice of corporate professionals. And I'm glad that Manish Ji is also joining you shortly and speaking to you and all of us on the various aspects of competition law. Earlier, he was heading the vertical of M&A, and therefore we can look forward to hearing him also. I'll briefly tell you a few things about competition law, and some of the takeaways would be built in within that. So, let me first of all start by mentioning the same thing which you also said. When I took over as first chairman of CCI in February 2009, there was very little understanding about competition law, and people used to ask me, "Hey, by the way, what do you do? Do you conduct competitive examinations like UPSC?" So people didn't know about Competition Commission. Situation has since improved. Much work has been done, but much more remains to be done. And this kind of a webinar is a building block in enhancing the understanding. The first bullet which you mentioned is competition law framework for businesses. Let me start by explaining the competition law framework for businesses and the role of Competition Commission of India as the key regulator. Globally, competition or antitrust law, as it is called there, originated from US, where it came up in 1890. In fact, from Canada, where it came up a year earlier in 1889. In 20th century, there were numerous cartels in Germany, Europe, and many other countries, in Austria, in Switzerland, in Italy, France, Scandinavia, and as far as Japan. As cartelization practices peaked during severe economic crisis of 1930s, European nations started to emulate United States by introducing antitrust laws therein. In India, the economic landscape of the country underwent significant transformation after independence, and the need of competition law or market regulation was increasingly felt by the policymakers. Following independence in 1947, the industrial policy was adopted to foster economic development, which necessitated regulatory interventions and the formulation of competition law, which would curb anti competitive practices. In the pre independence era, although the Indian economy was under the control of the British, there were select prominent industrial houses such as the Tata Group and the Birla Group. The colonial era left pockets of economic concentration with associated economic inefficiencies. The Indian industrial policy in 1948 played a big role in shaping the economic trajectory of the nation. The policy aimed to promote and protect economic development, providing a clear delineation of the state's role in commercial activities. Later on, industrial policy in 1956 marked the beginning of active government intervention in the industrialization process. Then the strategic sectors such as defense, steel, and coal were reserved for the public sector domain. A fallout was that the private enterprises faced restriction in obtaining licenses for setting up and running businesses. The restrictive policy of licensing regime and high tariffs imposed by the government, including price control on the output, limited the freedom of fair competition. You must be knowing, many of you, that at that time the prices of cars and scooters were controlled and one had to obtain licenses to buy one. The fostered This fostered anti-competitive behavior in the market, posing a threat to the interest of the general public. The need to address anti-competitive and monopolistic practices led to the formulation of MRTP Act, and as Pawanji just mentioned, Mr. Bhatia was earlier associated also with MRTP and he could possibly throw some more light. MRTP Act was aimed to prevent monopolistic and restrictive trade practices which would harm both consumers and service providers. This laid the ground for the evolution of competition law in India, including the Competition Act, which corrected the anomalies in the MRTP Act and set up a strong regulatory framework. Here I may also mention about the 1955 Hazari Committee report on industrial licensing procedures regarding the preferential allocation of industrial licenses, creating disparities and impeded balanced industrial development, by the way. This prompted recommendations for a more effective regulatory oversight, and then came the Mahalanobis Committee report in 1964, which emphasized that the economic model disproportionately benefited successful industrialists, leading to the concentration of income in the hands of a few industrial groups. Legislative roots of the MRTP Act can be traced to the directive principles of the state policy in the Constitution of India. Specifically, Article 39 B and C underscores the state's obligation to distribute material resources for the common good and prevent the concentration of wealth to the common detriment. MRTP Act was enacted with the overarching objective of curbing monopolies and restrictive trade practices. And this was to curb the concentration of economic power by various practices, and which also meant stunting the growth of individual enterprises. This also covered practices such as unreasonable pricing and pursuit of unreasonable profits. This brings me to the era when the country faced severe foreign exchange crisis, which led to the new economic policy of 1991, which aimed at unshackling the economy, freeing the market of licenses, controls, and regulations, and promoting private entrepreneurship. The 91 LPG reforms, the licensing, privatization, and globalization reforms, and the subsequent establishment of CCI are a more dynamic and effective competition law framework. The government set up a Raghavan committee in 1999, which laid the ground for the establishment of the competition law and policy, which covered basically the four pillars: enactment of a new competition law, establishment of a competition commission, prohibition of anti-competitive agreements and abuse of dominant position, and merger control and regulation of combinations. We shall elaborate on these a little later. The report stressed on the importance of fostering competition while safeguarding consumer welfare to ensure a fair and efficient market economy. It also stressed the government strategies and policies and their effect on the industrial systems and inadequacies of the industry to compete with multinationals. The objective of the competition law included promoting competition and sustained competition in the market, creating a level playing field, protecting consumer interests, and ensuring freedom of trade. And by the way, these were the 4 points which were also included in the preamble of the competition law. For consumers, it meant reduction in price, superior quality, numerous choices, and innovation. Competition law is meant to regulate the market, in fact, making markets work for the consumers, to accelerate economic growth, to curb anti-competitive agreements, and encourage new entrepreneurs, investment, and technology, essentially for static and dynamic efficiency. Markets keep on evolving. The dynamic nature of the markets, driven by technology, new products, digitalization, globalization, artificial intelligence now, which is the buzzword, and changing business models, they continue to pose new challenges and demands a nuanced understanding of the law in practice, which can play an important role in the rapid march to Viksit Bharat. One thing which I must emphasize, and you must remember that under competition law, everybody is a consumer, be the end consumer or producer who consumes intermediate goods or services in the production. So, by promoting healthy competition, efficiencies in the production, these legal frameworks prevent the anti-competitive agreements, and they can also, all these combined together, encourage innovation, efficiency, fair play, and lower prices, bringing in static and dynamic efficiency in the economy. You must also remember that competition law helps a level playing field for businesses, allowing new entrants to compete alongside the established players by lowering the barriers, promoting market diversity, economic democracy, and preventing concentration of economic power. A unique feature in our competition law is the level playing field between the public and private sector. This must be remembered. Under Section 2H of the Act, only the sovereign functions of the government are excluded, which include atomic energy, currency, defense, and space. All others are included. According to a High Court judgment, activities which are, and this is important, which are the activities of the government which are not covered by the competition law, which are primary to the government, inalienable, and non-delegable. They may belong to the government, others may not. One thing now which I may briefly touch upon is the competition policy. Competition policy, by the way, I was heading an expert committee comprising of experts to draft the competition policy, which I sent to the government. It's still lying there. In government activities, let us look at the Indian federal structure. Article 246 of the Constitution deals with 7th schedule of the Indian Constitution. It mentions 3 lists, namely Union list, which contains 100 subjects like defense, foreign affairs, banking, etc. State list, which contains 61 subjects such as police, agriculture, land, public health, etc. And the concurrent list common to both, which contains 52 subjects like education, electricity, forest, etc. So this is a division among the center, states, and common to them. And the idea under the competition policy that in each of these subjects, there should be an effort to infuse principles of competition law in order to get the best efficiency for the government in terms of allocation of resources and for the public by reducing the prices. What happens when a few companies coordinate their prices or production, creating anti-competitive agreement or cartel, dominating an industry? Obviously it is bad for the economy suffers, innovation stalls, consumers' choices shrink, and spending power weakens, market inefficiencies grow. The static and dynamic efficiencies, which I'm sure many of you, those who are familiar with the principles of economics know about it. Static efficiencies help in optimum allocation of resources. Dynamic efficiency help in improving productivity by induction of new technology over time, leading to long-term growth and enhanced welfare by better products. So both productive and allocative efficiencies are needed for a strong economy. By promoting healthy competition, competition law prevents monopolistic behavior, restrictive trade practices, and anti-competitive agreements such as cartelization, thus resulting in encouraging innovation. By the way, cartelization is excuse me, is a practice which is even criminal in USA and many countries in Europe. In India, it is a civil offense. It's not a criminal offense. But competition is Magna Carta of a free enterprise. In fact, in the American law, it is written that capitalism without competition is not capitalism, it is exploitation. Competition law maintains a level playing field for businesses, allowing new entrants to compete alongside the established players. It contributes to the overall well-being of consumers by ensuring and expanding choices, quality, and affordability, upholding the principles of fairness, economic democracy, and efficiency. Competition refers to a situation in a market where firms and sellers independently strive for the patronage of buyers in order to achieve a particular business objective. The firms strive to establish superiority over others. Let me talk about the establishment of a new competition law and a new competition commission, which was enacted in the competition law as per the recommendations of the Raghavan Committee. For the establishment of a competition commission, the committee recommended establishment of an independent regulatory body, CCI, which would be to enforce the competition law independent and investigate anti-competitive practices. It would be its duty to keep an eye on the market, promote fair competition. Prohibition of anti-competitive agreements and abuse of dominant position, and keep an eye on the combinations which are emerging in the market, which could mean becoming dominant and also adversely affect competition in many areas, and consumer welfare, which is important in the basic principle of preamble of competition law. As I mentioned earlier, the Act finds its roots not in just legislative enactment, but also in the Constitution itself, Article 38 and 39, as I said, and the directive principles of the competition. The preamble of the competition law, it says, this is an act to provide, keeping in view the economic development of the country, which remains the ultimate objective of the competition law, economic development of the country, for the establishment of a commission to prevent practices having adverse effect on competition, promote and sustain competition in markets, to protect the interest of consumers, and to ensure freedom of trade. Following the report of the Raghavan Committee, this new competition law was enacted, and it was passed in 2002, becoming a law in 2003, early 2003. And later on, there was a challenge to the competition law in the Supreme Court. And this brings me briefly to introduce what was there in the Brahmdatt versus Union of India. In this case, Supreme Court in 2005 looked at the competition law when the government appointed a few people, including the then chairman, who was appointed to head the CCI. The commission, the Supreme Court held at that time that there should be two bodies, two separate bodies, and they wrote about it, one with the expertise that is advisory and regulatory, and the other adjudicatory. This would be followed by an appellate body. So as a result, there was a competition commission which was an expert body, and there would be a competition appellate tribunal which would be headed by a former Supreme Court judge, which would be more of a judicial body in character. The competition amendment was carried out at that time in 2007, and therefore these two bodies were created. Competition Commission, CCI, was set up in 2009. I was privileged to be the first chairman. There were 6 other members, and the Competition Appellate Tribunal, COMPAT, was set up in 2009 May, and this was meant to hear the appeals against the orders of the Commission, and that role was later on given to NCLAT, National Commission, this body for hearing appeals of most of the body, National Company Law Appellate Tribunal. So these two are existing at the moment. Composition of the CCI, it was done according to what was set up at that time. The committee would be headed by either the Chief Justice of Supreme Court of India or a nominee Supreme Court judge. And then there would be experts who would recommend certain names to the government, and they would choose the chairman and the members from that panel, and the appointment goes. So it is the procedure which ensures that the chairman and members, they are independent and they cannot be affected. There were a few cases in the Supreme Court which were very important in the beginning, which laid the ground of what was to follow in the practice, the procedures, and so on. First was CCI versus the Steel Authority of India in 2010, which entered on the which decided on the CCI's procedural powers and the scope of judicial review. as the prima facie stage. I happened to be the chairman of CCI at that time. CCI had directed investigation against Steel Authority of India based on allegations by Jindal Steel and Power Limited, who claimed Steel Authority SAIL had abused its dominant position. Supreme Court emphasized that the objective of the Supreme Court, this Competition Act, is to ensure free and fair competition in the Indian market, protect consumer interests, and prevent anti-competitive agreements. Basically, what they said that it is not necessary for the CCI to issue a speaking order for ordering investigation, but they can give minimum reasons for investigation, enforcing strict confidentiality, and setting up a 45-day deadline for investigation reports. The court clearly held the CCI as a regulatory body has the authority to form a prima facie opinion, and that the prima facie order of the CCI was purely administrative in nature and not appealable. Furthermore, the CCI underscored that CCI is not mandated to record detailed reasons at the prima facie stage. These are the grounds on which we took the matter to the Supreme Court, and they made these decisions which laid the ground for subsequent cases which came up before the Commission. Taking a prima facie view and issuing a direction to the DG would not be an order appealable under Section 53A. The case of Steel Authority of India was extremely important, the first case which went to Supreme Court, and it laid the foundation for interpreting competition law not merely as a punitive tool but as a proactive framework for sustaining dynamic markets, which would also talk of allocative efficiency, productive efficiency, and dynamic efficiency. There was another case decided by the Supreme Court not around that time, much later. This was the short glass case, which laid the ground that there should be effect-based decision on the dominant undertakings and their practice in the market. They said that dominance itself is not anti-competitive, but it is effect of the conduct on the market, whether it is actually distorting competition or excluding rivals that must decide adjudication. In all, the Supreme Court held that in the business practices, it should be the effect-based conduct of the enterprise which should decide on this. I would leave out some of these factors because there is limited time. The Commission could also establish offices at other places in India. Now the CCI has its headquarters in New Delhi, and they set up their regional offices in Chennai for the south, Kolkata for east, and Mumbai for the west. The key takeaways from this, which we can take, is that the idea was to set up an independent and responsive competition institution which would be headed by reputed people, not affected by anybody else. And both the chairman and members should be people of distinction, repute, and designing efficient, transparent, and proportionate processes, fostering competitive market structures and dynamic efficiency, and prioritizing early decision. As I'm going to talk in a few moments, it is the mandate or it is the duty of the Competition Commission to ensure that the markets are functioning according to principles of competition law, and there is no cartelization, there is no abuse of dominance. So they have to keep an eye on the market all the time. So it is for this reason that the Commission has been given suo motu powers also. So whenever they feel that there can be a misuse, they can immediately take action themselves. Markets are not always under perfect competition, but whatever and whenever there is any distortion which is noticed by the Commission, they have to take immediate action. The key provision of the Competition Act, as it has been mentioned in the various bullets which have been circulated. Next one is Section 3 of the Act, which talks about cartelization when enterprises, persons, or associations they enter into agreements in respect of production, distribution, storage, acquisition, and so on.
Please one more.
Yes, and whenever there is any distortion to it, it would be taken care of, and the commission goes into it. I know that time is short, so I'll briefly mention about some of the key provisions. One is Section 3, which is the prohibition of anti-competitive agreements. Another is abuse of dominant position, Section 4, when a dominant undertaking undertakes abuse. Another is regulation of combinations. Sometimes companies they acquire one another and so on and become dominant, and then the commission has to look at it whether they can abuse their dominance. And by the way, there is a section 28 in the competition law which gives powers to the commission for breaking the competition, the dominant undertaking. So I use that in order to convince the businesses that they must allow the review of combinations under Section 5 and 6. There is a Section 32 which enables Commission to look at the acts taking place outside India but affecting competition in the Indian market under Section 32. So this is a power given to the Commission. Then Commission also has powers to issue interim orders under Section 33. The Commission, rather the Appellate Tribunal, has powers to award compensation to enterprises or to individuals who are adversely affected by any practice which distorts competition under Section 53N. They could be given compensation. There is a provision for advocacy, and the Commission has to undertake advocacy by educating people. And by the way, what we are doing today is also advocacy, although it is not mandated for the Commission now in this case, but this is helping the Commission and also the regulation of markets. So these are the various provisions which must be taken care of. There are a few things which I would briefly mention. One is the provision of dawn raids by the DGCCI, Director General. They can undertake dawn raids in order to detect if there are any papers which could be taken possession of. There is a provision of leniency by which lesser penalty could be imposed if the parties come voluntarily forward and disclose if there is any violation. In fact, there is a provision also for voluntary compliance, and this is also an area which could be open to the new lawyers or law firms to undertake voluntary compliance by the enterprises and also for the board of directors. The recoveries of penalties as areas of land revenue is something which you must be aware that if penalties are imposed, they can also be recovered as areas of land revenue. There is a provision of doctrine of essential facility, which is there in order to ensure that new firms can come up for using technologies, etc., which are necessary for their businesses and so on. The last point which I wanted to mention is about the 200 the latest amendments after the digital economy, the 2023 amendments, which talked about the deal value threshold, uh, which is basically for killer acquisitions or certain acquisitions where the value may be low, but the deal value may be high. Just for example, the Facebook, when it was acquired, when WhatsApp was acquired by the Facebook, its value was very low, but the actual value of WhatsApp was very high. So similarly, these days, a lot of new digital enterprises are acquired for the existing big tech and others for a very high value. So it is the deal value threshold, and if it is above a certain point, it could be looked at by the commission. The 2023 amendments also talk about reduced timelines and revised definition of control. It also talks about settlement and commitment mechanism. Recently, Google came forward before CCI and gave voluntary commitment. There are a few other provisions which are not that necessary for you to know at this moment, but it's very important for you to know that after the digital economy, it is extremely important that enterprises are aware of the various laws which are coming up for the digital economy in order to ensure privacy of the individuals for their digital details. And the artificial intelligence, for example, the commission recently came up with a market study, and it is extremely important that enterprises take up the voluntary compliance in terms of audit of what they are doing with their artificial intelligence work. There are no algorithmic collusions, and there is nothing like hub and spoke model and so on, the various things which commission looked at. So altogether, the idea is that the enterprises work according to the broad principles of competition law, allowing new enterprises to come up, allowing all the enterprises to work on the same platform so that they can progress according to their merits. Thank you very much for your patience, and I'm sorry if I have taken a few more minutes. And thank you, Pavanji, for giving me this opportunity.
Thank you very much, sir. Thank you. I know, despite of some pressure at family side, you have given this time to all of us, and your word of wisdom and your knowledge is far ahead. And the way you have explained the entire CCI gambit, it reflects that your initial work which you have done and the things you have merged together in a very short time, it's really commendable. Thank you very much, sir. And we will take up certain things and question our senses. So now I will request Mr. Bhatia to take up what corporate should do and what they should learn. What Mr. Chairman sir has said. Other than this, what message we should give to the corporate world and the professional that they should learn about the Competition Commission. Over to you, Bhatia sir.
Good evening. Thank you very much, Dhanendra sir and Pavanji, for setting the tone of the today's seminar. And the caption which we thought of today's seminar is what every business must know. So you are an executive in a business entity, and business entity is both a buyer and a seller. As a buyer, you procures lot of inputs, and you have to ensure that Is it that the suppliers who are providing me inputs, are they at cartelized price? Are you getting quality of acceptable level at affordable price? Is it that the price which is being offered is a competitive one or not? So your input cost should be competitive, failing which you will not be able to compete effectively in the domestic market as well as in the global market in case you are in the export business also. Likewise, you sell your products. So you sell your products, you enter into various kinds of agreements, and in while entering into agreement on your desk, you must ensure that it should not contain anti-competitive clauses or covenants. So we are going to discuss all these aspects when you enter into, when you evolve, draft, and review agreements which you enter with your verticals. When you are a member of a trade association, how you have to conduct yourself, how you have to ensure that trade association, which is a body, most of the time, it comprises of competitors. So what kind of information, how you have can give, and how the information being provided, competitive, sensitive information provided to trade association, is it that it is reducing the certainty of market certainty? Is it reducing, diminishing, or scuttling? If it is scuttling, suppose you are manufacturing tires. A company furnishes production information, supply position, price position to a trade association. Trade association receives similar information from other tire makers also. Is it that this information when you get from the trade association, is the element of uncertainty of market is reduced? If it is reduced, kindly ensure that such type of information ought not be shared with the trade association. So hence it is extremely important for you to understand the nuances and complexities of competition law. More than this, you are an enlightened citizen, and only on 23rd February, 4 days back, you must have listened a new Supreme Court order in relation to WhatsApp. WhatsApp, way back in 2021, came up with a policy that we will share the information of the members, WhatsApp members, with our group companies, Facebook and Instagram, etc. The CCI instituted inquiry, and there was no option, there was no opt-in, no opt-out. It was a policy of take it or leave it. So my information of Dhanenderji, information of Pavanji, and your information, as per the 2021 policy, WhatsApp mandated to the subscriber that in case you want to avail of the services of messaging business from us, we will share your information with our group companies. Failing which, you can take out your name from the WhatsApp group. And sir, interestingly, you will astonish that all panelists, all members of the audience, we are using WhatsApp. So over 95% market share in the messaging business is controlled and belongs to WhatsApp. With such sarcastic, such unilateral, take it or leave it approach has been found to be abusive, an unfair condition imposed by a dominant player, and an adverse sanction, cease and desist order was passed by CCI. They went in appeal to NCLAT. NCLAT endorsed this order, and then WhatsApp filed a appeal before the Supreme Court. And when it came up before the Chief Justice bench, he said, if in case you have to respect the Indian law if you want to operate and do business in India. And WhatsApp has now given an unconditional submission before Supreme Court that it will abide by the order passed by the CCI. See how important it is, directly or indirectly, you as an enlightened citizen, for me, for Pavanji, for Dhanender sir, all of us, how important it is for us to understand the jurisprudence which has been evolved in relation to data privacy, and the role of Competition Commission in protecting the interest of consumers and subscribers. And this discussion has become more important from 2023, though Dhanendra sir has given you fair idea about the changes which have recently been made. But the most important change which is relevant for audience is that now in-house counsel, general counsels can also be summoned by the Director General, and their statement can be recorded. Their evidence can be recorded on oath in relation to alleged anti-competitive agreements or in case of abuse of dominance. So unlike me, unlike as a external advocate, there is a privilege, attorney-client privilege I enjoy, but this privilege is no more available to general counsels and in-house counsels working as an employee with a company. Hence, you have to be extra cautious that you ought not enter into any kind of correspondence or agreements which can give rise to competition concerns. Next slide. So Pawanji has given you a broad idea that there are three major dimensions of the Competition Act, and one of the dimension relates to merger control. And the unique feature of merger control is that this is enforced ex ante. Ex ante means before the merger takes place, before you consummate the transaction, you are required to take prior approval of the Competition Commission of India. So an obvious question will be in your mind that when I am taking approval under company law, when I am taking approval under SEBI, when I am taking approval under regulatory laws, if it is a bank from RBI, if it is an insurance company from IRDA, what is the need? Why under competition law, a merger needs to be approved by the Competition Commission? The answer is that in company law, the approval is with the perspective of shareholder interest. In the case of SEBI, it could be minority interest. In the case of banking approval from RBI, it could be in relation to banking sector. But so far as Competition Commission is concerned, they have to see from the market angle, is it that the combination in the market is going to affect substantially, appreciably competition in the market or not. For example, I'm a resident of Shalimar Bagh in Delhi, and there are only two banks branches. One is Bank of India and another is Punjab National Bank. If they merge as against two outlets, as against two branches which are available to me, for me as a account holder, there will be only one branch. So that means in the Shalimar geographical market, there is going to be something dominance in the banking sector. Hence, this is the remedial action can be taken, and CCI may allow the merger, but it will say that in all those residential colonies where only two banks branches operate, in those areas, this one of the branch should be handed over to third bank so that competition, the fabric of competition could be maintained. The other two dimensions, anti-competitive agreements and abuse of dominance, they are regulated, they are enforced ex post. That means after the event has occurred. And as Dhanendra sir has mentioned, that way back in 1991, we opted for a policy of liberalization. In the wake of policy of liberalization, deregulation, and current policy of the government of ease of doing business, agreements are not required to be filed with the Competition Commission or with the DG office. You can go ahead with agreements, but only thing is that subsequently, if it is noticed that the agreement which you have entered into, they give rise to competition concerns, action could be taken, and severe action is taken. So I think next. So when you go ahead with the term sheet in relation to acquisition or merger, kindly remember that you don't take steps towards the consummation of the transaction. First, you have to examine, is it that this transaction is required to be notified to CCI. If this transaction is required to be notified and you don't notify it, or you notify it without waiting for the approval letter, you go ahead with consummation of the transaction, it gives rise to a case of gun jumping. So it is mandated that no doubt you have agreed to merge, no doubt you have agreed to acquire, but that transaction will be subject to standstill option. And in case you go ahead without obtaining prior approval of the Competition Commission of India, it triggers gun jumping provisions and penalty provisions. So there are thresholds. It's not that every merger is required to be reported, notified to CCI, and you have to wait for the approval of the CCI. If the target is a small one, if I'm embracing an entity which is small in size, and that small in size is assessed if asset is less than 450 crores and turnover is below 1,250 crores, in either of the situation, this merger is exempted from the provisions of the competition law. You can go ahead without notifying to CCI, without waiting for the approval of the CCI. This is called de minimis transaction. Now, if de minimis transaction you cross, de minimis threshold you cross, and then the entity is having assets more than 2,500 crores and turnover. So there is a ratio of 1:3. If asset is 2,500 crore or turnover is more than 7,500 crore, and if it is a group entity, then 10,000 crore and 30,000 crore is the threshold. If you cross any one of these limits, then that transaction, that means substantive limits are crossed and you are mandated to apply for approval of the CCI. A new, as Dharinder sir has mentioned, a new threshold has been inserted because it has been seen that many times the transaction values do not cross the threshold, but the consideration which is paid by the acquirer or by the consideration involved is if it exceeds more than 2,000 crore, that target acquisition or merger is also required to be reported. And kindly remember that when this DVT, deal value threshold, is more than 2,000 crore, then those de minimis exemptions or exclusions, that benefit is not available. So in case of when the transaction value is the criteria for the applicability of a transaction, this de minimis exclusion benefit is not available. Now, if it is an intra-group transaction, within the group there is a restructuring, there is an exemption available. If minority investment you are making less than 25% market share, and it is solely with the intention of an investment only, then again it is in the exempted category. But kindly remember, if you are making acquisition in a competing business, then it is not considered solely as an investment, and this benefit of exemption is not available. Then there are three forms: Form 1, Form 2, and Green Channel. If you are going to acquire a business where neither there is a horizontal overlap, nor there is vertical overlap, nor there is any complementary overlap. So in a transaction where there are absolutely zero overlap between the acquiring entity and the merging entity, then you can file a green channel. Green channel means that you file a notice at the counter of the CCI. The moment you get an acknowledgement, the transaction is deemed to have been approved. Then there is Form 1. In case the target as well as merging entity, both entities, target and acquirer, in case your market share does not exceed more than 25%, then Form 1, 15%, then Form 1 is required. And if it is more than 15%, Form 2 is required. Form 1 means less details are required. Form 2 means more details are required. The filing fees in case of Form 1 is 30 lakh rupees, and the filing fees of Form 2 is 90 lakh rupees. Next slide. Now, Competition Commission, if they find, as I mentioned you, a case of in the bank merger, if they find that here is a case, we can approve the transaction, but certain remedial action is required. So the remedial action can be either structural or behavioral. In the case of behavioral, generally they give a direction that, okay, you can go ahead with the merger, but you will not increase the price of the product in the next 3 years. Or you will continue to produce the product in the next 3 years. So any kind of stipulation in relation to behavior, conduct of the business, that remedy can be provided by the CCI, or structural remedy can also be provided by the CCI. CCI may say that one of the segment of your business, this you have to hive off and hand over to a third party so that the fabric of competition could be maintained. Such kind of divestment or structural changes can be suggested by the CCI. Incidentally, more than 95% of the transactions which have been filed so far with the Competition Commission have been approved unconditionally, without any conditions. Neither there have been any behavioral nor structural modifications have been made. Only in less than 5% of the cases, out of the 5% cases, 70% cases only behavioral remedies have been given, and only in 2% cases structural remedies have been asked by the CCI before approving the transaction. Now we come on the most important aspect of anti-competitive agreement. Sir, you know it that more than 95% of the commercial transactions are done through agreements. And agreement has got a very wide definition under the competition law. Under competition law, agreement, whether it is formal or informal, whether it is oral or reduced to writing, whether there is an understanding or action in concern, all these are agreements. A wink or nod or showing thumb constitutes acceptance of promise and tantamounts to agreement under the competition law. So one unique feature is whether the agreement is reduced to writing or not, whether agreement is enforceable or not. But if there is an agreement or understanding or arrangement, it is an agreement for the purpose of competition law. Now, when you sit on your desk and ask a question to yourself, that is it, so 3 conditions first you have to see before examining from the anti-competitive angle. First condition is this agreement is between 2 independent parties? Is it that parties to agreement are independent? So in this connection, I will give you an example. If holding company is going to enter into an agreement with its subsidiary, 100% subsidiary, a controlling entity and controlled entity, if there is any kind of agreement, this agreement does not fall within the purview of Section 3. Then the second question will be, is it that the agreement relate to production, supply, or distribution of goods or services? In case the answer comes in the affirmative, that means you have to look at Section 3 of the Competition Act. On your desk, you have to review from the lens of Section 3 requirement. Then agreement could be a structural agreement. For example, you are entering into an agreement relating to acquiring another entity or acquiring 10% share in another entity. This is also an agreement, but this agreement relates to changing the structure of the organization. It is covered under combination agreements and not under anti-competitive agreement. Anti-competitive agreement provisions do get triggered when the agreement relates to production, supply, or distribution of goods or services which are produced or rendered by the company concerned. Then the last touchstone is it that this agreement going to cause or likely to cause appreciable adverse effect on competition in the relevant market? If the answer as per your conscience comes to be in the affirmative, then take it that it is going to be an anti-competitive agreement. Now, what are the things which you have to keep in mind before coming on the conclusion whether it is an anti-competitive agreement or not. इसको भी छोड़ो, price पीछे वाली. Yes, if you are entering into an agreement with a competitor and you are entering into an agreement relating to price fixing, sir, these are per se bad. These are horizontal agreements. So you have to ask a question: is this agreement a horizontal one or a vertical one? Horizontal agreement is generally entered into with a competitor. Vertical agreements are generally entered with a verticals, who can be your dealer, who can be your distributor, who can be retailers. So these are vertical agreements, sir. So if with a competitor you are entering agreement relating to price fixing, as Pawanji mentioned, you decide that cement bag I will sell at the same price as that of a competitor. If there is any kind of arrangement, understanding or agreement, it is you are entering into a cartel arrangement. And it is per se bad. It is because competition reduces the price, and here you are entering into an agreement whereby price is being fixed, and hence then there is market allocation. As Pawanji mentioned, I will sell in Punjab, you will sell in Karnataka. Third person says, I will sell in Tamil Nadu. Fourth one say, I will sell in Himachal Pradesh. Market allocation. Territorial allocation of markets is per se bad. Likewise, if there is any kind of arrangement that I will sell to the OEM buyers and someone will sell to the retail market in Karol Bagh or in Johor Bagh market, this is also a market which happens generally in tire market. It is also a case of market allocation. If at a trade association, competitor decide that we will reduce the production of car tire by 15%, and if the output restriction is without any rhyme and reason, it is only with the intention to firm up or inflate the price of the tire, then it is this output restriction arrangement is hit by Section 3 of the Competition Act. Then there is bid rigging. That means a tender is floated and you are responding to the tenders. If there is any kind of collusion, if there is any manipulation in the tender process, and you are rigging the bids or you are colluding in the bids, it is also judged by rule of by per se rule, and it is hit by Section 3 of the Competition Act. So bid rigging, price fixing, output restriction, market allocations, they are per se anti-competitive agreements. They are presumed to have caused appreciable adverse effect on competition. Now, there can be a case of hub and spoke. Prior to 23, the law was say that in case of cartel arrangement, parties must be engaged in identical or similar or same business. That means cement companies, all of them are making gray cement. Hence, cartel arrangement can be only between and amongst the cement players. But now, if Cement Manufacturer Association, at the platform of the association, if something is being cooked up in relation to cartelization, now trade association can also be punished. The office bearer of the trade association can be punished, as well as the cement company can be punished. So this is hub and spoke. CMA is acting as a hub, and cement companies are acting as spokes. Hubs are being mandated by spokes, and spokes are under the obligation of the hub. So such kind of arrangement is also considered as a case of cartelization under the Competition Act as per the amended law. Next. पीछे वाली इससे पहले वाली. Now we come on vertical agreement. vertical agreements are, there is no presumption of appreciable adverse effect. You enter into an agreement with a stockist, Hindustan Lever, it's or Colgate. Colgate 150 toothpaste is very much in demand, but Colgate toothbrushes are not in demand. But when the market person of Colgate goes to retailer, he says that, okay, we are ready to give you toothpaste, provided you also buy a basket of toothbrushes also. This will be construed as a tie-in arrangement if two different products and the second product is being dumped against the choice of the buyer, then it can make a case of tie-in arrangement. Bundling is also a vertical agreement. Many a times when you go to KFC or somewhere, they say that this total package we will give to you at this price. It is a case of bundling. But kindly remember, all tie-in arrangement and bundling and exclusive supply arrangement, resale price maintenance, refusal to deal, these vertical agreements are not per se bad. If you can justify before the competition commission as and when inquired into, then these agreements are not bad. If your market share is very insignificant, that means it is, even if it is anti-competitive vertical agreement, even then it is not expected to have caused appreciable adverse effect because your market share is insignificant. Likewise, if you can insert the justification, what is that which persuades you to do business like this? If your justifications are acceptable to CCI, again, such vertical agreement will not be frowned upon by the Competition Commission. Next. Sir, the second limb is abuse of dominance, and I have given you a case of WhatsApp. WhatsApp has been found to be dominant in the messaging market, more than 95% market share, and that's why they have been punished. And now they have undertaken before the Supreme Court that not they will abide sincerely by the mandate given by the CCI. Now, and so how to determine dominance? Are you dominant or not, sir? This is the most essential. I think this is the most important feature of today's seminar. You need to assess yourself. Is it that I am dominant in a, you may be a multi-product company. For example, a pharma company is there and you are manufacturing blood pressure capsules. And in the blood pressure market, there is a high degree of dependency of the consumers, of the patient of blood pressure. So you can be labeled as a dominant player. And if you are dominant, it's not that dominance is bad, as Pavanji has mentioned. Dominance is not ugly. The only restriction, the only obligation, responsibility on a dominant player is that there are certain conducts which you are forbidden to do. If you indulge in any of the abuses because of your market power, then certainly you can be hauled up by the Competition Commission of India. And there is an English maxim, power corrupts and absolute power corrupts absolutely. So when you are controlling the market, either by virtue of your assets or by virtue of your market share, you are likely to be hauled up by competition commissions. Drinking is not bad, but drinking and driving is objectionable under traffic norms. So is the case in case of abuse of dominance. So wisdom suggests that in case you are held to be dominant, you ought not indulge in certain conducts which are enshrined in Section 4 of the Competition Act. And if you do so, you are doing so at your risk and you will be liable for the penalties. So now what are the factors which CCI looks at when your inquiry is initiated? Market structure, who are the players, what is your size, what are your resources, and what is the size and resources of your competitors. In the WhatsApp matter, the CCI found that there are two other players, Telegram and Signal, and they have got insignificant, less than 2% market share. More than 95% is enjoyed by WhatsApp only. So your market share, your size, your resources, who are the resources, size, of the competitor will be looked into by the Competition Commission while determining the dominance part is concerned. Similarly, entry barrier. Are there entry barriers? Are there entry barriers? If there are entry barriers in mobile market, there are circles, and government has got a policy not more than prescribed number of player can operate in that area. So entry barriers are through the regulation. Likewise, could be there in the life insurance business also, there could be entry barriers. Economic power. What is the economic power and the extent of dependence of the customer will be another feature will be looked into. Now with the WhatsApp order, data power, data bank power is perhaps can be used by the Competition Commission as one of the factor while assessing dominance of an enterprise. When you are dominant player, Dhanender ji has mentioned freedom of to carry on trade. When there is a dominant player, as happened in the case of DLF in Gurgaon territory, DLF was found to be dominant because the number of apartments in the range of 1.5 crore to 2.5 crore in 2013-14 was found to be highest. And on this ground alone also, and plus seeing the value of the land bank and the location of the land bank, DLF was found to be dominant. And because of some of their abusive conduct, including the fact that they projected to the potential buyers that we will have it only 19 floor complex, while when the money was accepted later on, they changed it to 29 stories. And the grievance of the flat buyer was that, sir, the ambience has not undergone change, while the number of flats which have now constructed, they are far more than 40% of what was projected. And hence the size of the interior roads, the size of the pool, the size of the club has not undergone change. So the ambience which was projected was found to be deficient. And that's why action was taken by CCI against DLF. So abuses could be exploitative. Exploitative abuse means unfair price, and it can be discriminatory conditions, discriminatory price, and exclusionary could be that you adopt predatory pricing. Predatory pricing means selling goods below the cost of production with the intention to eliminate or oust a competitor from the market. If the cost of production of making cup of tea is 25 rupees and I sell it at 5 rupees only with the intention to eliminate competitor from the market, it would be a case of predatory pricing. This is an exclusionary abuse and it is objectionable under abusive conduct of a dominant enterprise. Next. Now, fourth requirement, which comes to the rescue of the business entities, sir, is that now the Supreme Court in a recent judgment of May 25 in Short Glass case has said that merely you are an enterprise, you are dominant in the relevant market, you are indulging in one or more of the abuses enshrined in Section 4 of the Act will not suffice. CCI has to look on the effect part, because the substance of the law is that whether it is anti-competitive agreement or abuse of dominance, it must result in appreciable adverse effect on competition in the market. So the requirement of effect touchstone has been reassured by the Supreme Court, and now there is a mandate on CCI. Instead of 3-step inquiry, now abuse of dominance has become a 4-step inquiry, and the last step which it has to comply and honor is that CCI must look at whether the abuse has resulted in appreciable adverse effect on consumer, appreciable adverse effect on market, appreciable adverse effect on competitor. If these touchstones are also, this touchstone is also required to be satisfied by the Competition Commission of India before passing cease and desist order and before imposing penalty. Why it is important for you to understand the nuances of the Competition Act is that apart from penalty which is imposed on the competition on the delinquent company, penalty can also be imposed on the delinquent KMPs also, on the executives also. And the penalty which can be imposed is up to 10% of the income which you have shown in your income tax return. For the last 3 years income tax return, an average income drawn by you from the enterprise will be considered as a benchmark for determining penalty. So up to 10% you can be punished, and it is not indemnified. This amount cannot be indemnified by the employer legally. Next. So why it is important to ensure that you are compliant of competition law is time and litigation cost. And as per the Paytm Managing Director's statement, compliance cost is minuscule for the total havoc, total loss which is caused to an organization in the event of non-compliance, in the event of violation of a competition law. Here penalty can be up to 10% of the turnover, which can be even global turnover. So you can imagine that what is the cost of compliance? For doing compliance program, how much is the cost? It will be, I think, less than 0.0001% of the total penalty which you pay for in the event of violation of a law. Litigation costs, time involved, and so there is huge cost involved for compliance of it. Monetary penalties, I have already explained you, up to 3 times of profit for each year of continuous, or up to 10% of the global turnover for each year. So in case of cartel, if the cartel has continued for 7 years, the turnover of all 7 years will be taken into account. It will be aggregated, and penalty can be imposed up to 3 times of profit or up to 10% of the global turnover. So it is not 3-year average turnover which is taken into account, as in the case of vertical agreement or in case of abuse of dominance. In case of cartel, it is 3 times of profit or up to 10% of each year of violation. In the case of cement, where the penalty has been imposed 6,300 crore, it has been imposed at the rate of 0.5%, 0.5 times of the total profit of the cement company. Imagine, the power is 3 times, but CCI only imposed 0.5 times, and 0.5 times has come to 6,300 crore. In case of abuse of dominance, up to 10% of average turnover of last 3 years. In case of individual, average income of the last 3 years is the benchmark for determining penalty on the delinquent company or delinquent individual. There the CCI has issued guidelines. CCI has issued guidelines. Back. CCI has issued guidelines, and in the guidelines there are aggravating factor and mitigating factor. Mitigating factor are whether you have cooperated with the investigation and whether you have established competition compliance program within the organization. In case an inquiry is instituted and you have not established competition compliance program within the organization, you will have no mitigation factor. Penalty can be up to 10% of the penalty. So in order to avail of the benefit of mitigation, in order to have reduced penalty, it is all the more advisable that the company concerned must establish a competition compliance program. The aggravating factors are whether you are a repeat offender or not, whether you are a ring leader or not, whether you are a follower or a leader. All these aspects constitutes aggravating factor in determining the penalty. Mr. Dhanendra Kumar has given you fair idea about commitment and settlement claim also. But kindly remember, in commitment, the commitment can be given before receipt of the investigation report. And so far as settlement is concerned, it is given after the receipt of the investigation report. But it is not that much relief is given in case I am an applicant for settlement. In case of settlement, you have to settle the matter with the CCI, and in the whatever will be the leviable penalty in the eye of CCI, 15% rebate is given in case you are a settlement applicant. So the wisdom again suggests that instead of going ahead with commitment or settlement, because you have to pay settlement fee also to the Competition Commission, it is again advisable that you must ensure that you are consistently found to be on a right side of law. And that is possible only if you establish competition compliance program within your organization in case you want to defend the company and you defend yourself also. In addition to penalty which can be imposed, the aggrieved person can also ask for compensation for the loss which he has suffered as a result of indulgence in anti-competitive practices or abuse of dominance. So you need to review all your contracts, arrangements which you have entered into. You need to review your all joint venture agreement. Even in the joint venture agreement, there can be non-compete clause. There can be clause which can give rise to competition concern. There should be transactional due diligence before you enter into any transaction, before you sign any term sheet. You must ensure to look at from the competition law perspective. Is it that in case I go ahead with this transaction, is it that I am required to notify this transaction? Does it cross the de minimis and substantive threshold? Is it that the transaction can avail of the benefit of exemption which have been made available under the rules of issued by the Government of India? Or is it that this transaction is entitled for any other exclusion or exemption or under Section 54 of the Competition Act? So transactional due diligence from the lens of competition law would be advisable. And then competition jurisprudence is ever evolving. And hence there is a need from time to time, there should be an updation, training program, and continuous education will be advisable. And oversee all interaction with competitor with a specific focus on activities with trade association. We must be very conscious of. So we need to evolve a mechanism. If any of the senior executive of your organization is going to meet a competitor office or competing official, there must be a mechanism of seeking permission, and he must report back what he talked, what he spoke, what he discussed, and whom he met and at what time he met. So everything, it should be recorded so that in the event inquiry comes, you are not hauled up and you are able to explain what he discussed during the meeting. Since I have been a defendant counsel in various matters, it is my experience that please don't do things orally. Evolve processes. Absence of process will always create suspicion. Why you are quoting a particular price in response to a tender? There should be some independent record, some committee should be formed. There should be exchange of mails internally within the organization so that you are able to demonstrate that what we do. Next. Sir, I think now Vatsala can take over, sir, so far as digital part is concerned.
Okay, Vatsala, you just tell us about the digital jurisprudence issue and how this is changing. Over to you.
Sure. Thank you so much. And thank you, Mr. Bhatia, for this very comprehensive coverage of the antitrust issues with key exposures and risk mitigation. This is a kind of good segue to what we are going to cover and address the next. So in present times, we see the markets are evolving in a very rapid pace. And for the longest time in the past, the focus of regulator was towards the traditional industries, like we discussed in automobiles, spare parts, papers, or let's say LPG and tires. But now we see a drastic shift in the market where the regulator is also considering regulating digital industries. If you can please move to the previous slide, just to give you a few examples, we have enlisted that how the things used to look and still look in the traditional industries and how they have changed with coming of this digital era / regime. Um, can you move to the previous slide? Okay, so traditionally we were worried about a company refusing to sell a particular specific physical part to a rival, and we colloquially called it as refusal to deal. Today we worry about self-preferencing. For example, a giant platform that owns both, let's say, marketplace and a private label, if they ensure that their own product shows up as #1 search result, that may amount to abuse of dominance. Likewise, in traditional competition law, we often deal with RPM, which is resale price maintenance, and this is where the manufacturer who operates in a kind of upstream market tells a distributor who operates in downstream market that you cannot sell this product below, let's say, X rupees. The concern there was straightforward, that it restricted the price competition at the retail level. But now in digital economy, we see similar concerns, but in a more sophisticated form. That's what we call an anti-steering. Now, instead of fixing resale prices directly in digital platforms, say, let's say an app store prevents app developers from telling users that the app is cheaper on the developer's website. So the platform in this case isn't necessarily fixing the price, but they are blocking the price transparency. We have listed a few other examples for your perusal. You can move to the next slide, please. So these concerns we spoke about stem from some very distinct features which are unique to digital markets, and that's one of the reasons they cannot be regulated as traditional industries. The first one would be that in the digital markets, the value of product isn't about its feature, but it's equally about its user. For example, once a platform reaches a critical number of masses, the market tips, which means it becomes a natural monopoly because users feel that they must stay where everybody else is. This kind of creates a massive entry barrier for budding startups, regardless of how good or excellent their technology is. Second would be, in this particular AI era, data is no longer just an information. It is a kind of strategic asset, which means that more data leads to more better AI, which attracts more users who then generate even more data. This data-driven network effects makes the leader position nearly unshakable, and it is very difficult for a newcomer to replicate years and years of historical user behavior overnight. The last and the most important one would be that for decades, regulators used SNP test, that was small but significant and non-transitory increase in price, to catch monopolies. Let's say if a company raised prices marginally, for example, 5%, and people didn't leave, there was a likelihood that the company had the monopoly in the relevant market. But the conflict with today's digital age is, how do I apply this to Google, Facebook, or WhatsApp, where the price is zero? Users pay with privacy and data and not money. And hence, traditional substantive assessment in this case would not work in the given circumstance. Now, next please. What is regulator doing about it? Answer to this question is the subject of core legal antitrust debate in India in present. And presently, enforcement by CCI is largely, as the speakers before we mentioned, is ex post. That means the CCI steps in after the harm has occurred. It investigates, it gathers evidence, it hears parties, and then issue a final order. But the real challenge in this kind of digital markets is markets move very fast, and sometimes they move even faster than the enforcement time. So in many cases, the duration of investigation exceeds the lifespan of the competitor. And by the time when any substantive order is passed, the market may have already tipped. Recognizing this challenge, the Committee on Digital Competition Law proposed a shift towards an ex ante framework by Digital Competition Bill. The idea was that instead of and made subject to some of the hard obligation. But the bill was withdrawn in August last year owing to some factors. This was somewhat rigid, and this ex ante regime was floated without comprehensive market study. Also, we do not know that whether as an economy India was ready for it. The concern was that overregulation could unintentionally may harm ease of doing business, and that can, slow down the growth of India's ecosystem. So today, the debate as it stands is not whether digital market needs regulation or no, but how fast, how strong, and how preventive that regulation should be. That's something regulator is currently working on. Next, please. Now, any discussion on modern competition cannot be concluded without addressing not so new kid on the block, which is AI. So if you are a corporate deploying AI tools, you may be particularly interested to know what all CCI is doing in this AI space. Last year, the Commission concluded its study on AI and competition. And as of now, CCI has taken what we call a careful and balanced approach. They are not rushing to impose the strict rules. Instead, they are studying the market very closely and collecting evidence before they decide whether stronger regulation is needed or not. Next, please. Just quickly, this is how they have kind of categorized the market in two layers. The first layer is an infrastructure layer. This is the layer where we have companies that control the basic building blocks like cloud services, powerful chips. These are the companies where there is very less competition, but the magic happens in the second layer, which is called the application layer. We have a number of startups and developers in the second layer. In fact, very interestingly, 67% of Indian startups operate in this application layer. So these startups, they use large AI models and adapt them for specific use like healthcare apps, tech app, finance tools, customer service bot, and etc. etc. And I'm very sure some of you would be deploying and using these tools in your organizations as well. The regulator kind of flagged some competition concern in the study as well. The first one was algorithmic collusion we discussed in the last part, and this is the kind of risk where AI system might automatically adjust price in a similar ways without actual human being directly involved ever. Second one was self-preferencing, AI-based price discrimination, and high entry barriers we have already discussed in the last few slides. Next, please. So after identifying the challenges, instead of immediately imposing strict rules on the corporate, the CCI at this point is encouraging companies to kind of act responsibly. And this is the part which is extremely, extremely important for you as a business. If you are a business which is built around, or if you are a business which is kind of deploying AI for the commercial purposes. So there are some guidelines and suggestions which the studies puts forward. Next, stay. The first one is that companies should regularly review their AI system to make sure they are not accidentally causing competition concern. Think of it like a routine health checkup. An algorithm might start out working fine, but eventually it can learn to favor its own company or product, or even it can start matching prices with competitor in a way that is not very in the interest of the competition. In that case, if your AI causes a market problem, the machine did it isn't a valid excuse. You have to be proactive. Second, there should be more transparency. As a company, you should be able to explain how your AI systems make important decisions. And even if you don't reveal the full code, that is not the requirement, but there should be some kind of explanation. If AI makes a big decision, like if in your company, if you are dealing with, let's say, finance service or something, and if AI makes the decision like who gets the loan or which seller gets on the top of the website, if you're operating a buyer's a mercantile marketplace. So the logic behind those decisions shouldn't be a mystery. We need enough transparency so that the regulators and users can see that the playing field is still level. Lastly, everything said and done, the CCI is itself deciphering and building its own expertise, possibly through a specialized AI think tank, so it can understand this very fast-paced, fast-moving markets better. So overall, the current approach with respect to the conundrum of AI, competition, and digital market is that monitor first, regulate carefully, and step in very strongly only if it's extremely necessary. Next, please. So that was all from our end for this segment. Thank you so much. Over to you, Mr. Vijay.
Okay, thank you, Bhatia sir. Thank you, Vatsala, for giving detailed presentation on this particular concept of CCI, what industry should know. No doubt, this topic is very technical and very, very important, which everybody can understand that if you're not learning, it will be a problem. Because we have already overshooted time, so I have various questions, but I will ask. There's one question has come, and few questions are with me. In current insurance industry practice, insurers often refuse to allow a change of broker from A to B unless no objection certificate is provided by the existing broker. Since brokers are unlikely to issue such NOC due to loss of income, this effectively blocks client from exercising their choice. Given that this practice widespread and known to Bima, Lokpal, and IRDA, what resource should policyholder and new brokers have to ensure fair competition and uphold the principle of client choice? Dhanendra sir, can you just tell us what?
I'm sorry, this is not my subject at all.
Okay,
This would be
Bhatia sir.
relatability only.
Yeah. So, sir, I think before dealing with this question, one important thing which we have to note is there any guidelines issued by IRDA which govern the broker's business? If there is some guidelines and that guidelines is not being complied with, action can be taken by IRDA. If there are no such guidelines, certainly it can be examined under the competition law, because you are not allowing freedom to carry on trade.
Okay. Sir, can you just tell us what are the three major dimensions of competition law? Bhatia sir?
Yes. Sir, as you yourself mentioned and I covered in my presentation, the three major dimensions of the competition law are anti-competitive agreements, abuse of dominance, and regulation of mergers. And as I mentioned, every agreement is not anti-competitive, but certainly you all professionals need to ensure that when agreements are routed through your desk, those must be compliant of the provision of competition law. And if need be, the advice of external counsel should be availed of. Similarly, you need to assess whether I am a dominant in a particular segment of the business where I am operating, what is the fabric, what is the structure of the market, and in case my market share is more than 20 to 25%, certainly it will be in the interest of company concerned to ensure that they are not found to be abusive, found to be in abusive conduct. And as I mentioned, so far as merger regulation is concerned, you need to take into account the provisions of combination regulation under the Competition Act, including rules and regulations, including decisional practices of the CCI when you enter into any structural change agreements.
Okay. Sir, Dhananjay sir, what are the current thinking of the government regarding proposed digital competition bill? Unmute please yourself, sir.
According to various indications and also the media reports, right now the digital competition bill is not really in a rush being taken forward, and it's lot of consultations are still going on. So I don't expect this thing to go so soon in the near future.
Okay. Bhatia sir, you have worked in MRTPC also, you know MRTPC law. Unlike MRTPC Act, it is said that CCI bites and bites bitterly in the event of violation. Why is enforcement perceived as stronger today?
Yes, obviously, as Sir also mentioned, Dhanendra sir, and I also mentioned in my presentation, and you people, audience is fully aware that the CCI has got, unlike under MRTP Act, there was no provision to punish. There was no provision of imposing any monetary penalty. Under Competition Act, up to 10% or 3 times of the profit, a penalty can be imposed in case there is a case of cartel, and average turnover up to 10% can be imposed in case of abuse of dominance. Likewise, in mergers also, sir, in case you don't notify a notifiable transaction, or you notify in a very casual way and it is almost a doesn't give the complete sense to the Competition Commission of India, penalty provisions do get triggered. And it is not only penalty which can be imposed if you consummate the transaction without approval. The Competition Commission has got power to bring back the original status of the parties.
You also should know that there are provisions of penalties on individuals also. Not only the enterprises, the individuals who are responsible for the violation, for the infraction, they are also liable for penalties. And these have been imposed in the past.
Okay. Okay. Bhatia sir, it is said that beside the company, CCI can impose penalty on individual. How serious is personal liability for director and KMP?
Sir, direct response. So there are deeming provisions, sir. Penalty can be imposed on delinquent KMPs. There are only 2 escape valves which are made available under the law. If the alleged delinquent person can demonstrate and convince the Competition Commission that there has been absolutely no negligence on my part so far as commissioning of this contravention is concerned, and secondly, that I have taken due diligence steps to ensure that contravention doesn't take place. These are the 2 only escape valves, failing which penalty up to 10% of the average income which the gentleman has shown in the last 3 income tax returns is liable for penalty.
Dhananjay sir, trade associations serve the industry but often become vulnerable to violation. Why?
Trade associations are a platform where the competitors or potential competitors, they assemble and exchange information. This is a platform provided for exchange of information. For example, if they have to submit a representation to the government, or the kind of exchanges which help in promotion of the industry or their projects. But sometimes they exchange notes on the pricing, on production, and so on, which can impact the competition in the market. And they are very vulnerable in such situations. If it is proved that they have exchanged information, then not only the people concerned, but also the trade associations, they are vulnerable for fines.
Okay. Okay. Sir, last question. Bhatia sir, can you just tell what should the board do to ensure that company remains on the right side of competition law?
Absolutely, sir. In every at least, sir, after every two or second or third board meeting, sir, there should be review of our all marketing practices, agreements, and a report should be furnished and placed before the board. Is it that competition assessment has been done or not? Has there been any structural change in the various segment of markets where I operate, where the company concerned operate? So complete landscape of competition in all markets need to be reviewed at the level of board so that this board resolution and board review report can be placed before the uh, CCI in the event an inquiry is instituted. More than that, sir, board must ensure that the company concerned has established comprehensive compliance program in place. Not that after the inquiry has been instituted. If we establish the compliance program after inquiry is instituted, then sir, that benefit, that perception will not be right. Perception will be created.
Okay,
So-
okay, okay, sir. Because time is already we have overshoot the time, so we have to. It's a time to close. Before closing, sir, I just want to take 30 seconds from everybody to talk about this summary of this this concept and this CCI. I will start with Vatsala. Vatsala, what is your view about this topic and this particular future?
Thank you so much, sir. So, as a professional, I am very, very helpful, and I really do believe that it is very, very interesting time for competition law and competition law practice, and just in for Indian economy as a whole, because we see, although the digital competition bill, etc., has been withdrawn, but we are very hopeful that the CCI is definitely coming up with something which is more nuanced, more informed, and more substantive, and we will see a lot of growth in this particular area. So I'm very, very optimistic and hopeful about it.
Okay, Bhatia sir. Sir, unmute please. Sir, unmute yourself. Yeah.
Am I audible, sir?
Yeah, yes, sir.
Yes, I think a time has come when all companies concerned and individual should ensure that they are compliant of the law worldwide, and so is the case in India also. Penalty provisions are being tightened and enforcement is coming in a big way. So wisdom suggests that companies should ensure compliance of law, and therefore that the company should train their officials. They should update themselves with the latest changes, latest jurisprudence which is evolving, which is developing in the competition landscape. And secondly, no doubt the digital bill has not come. The Competition Commission of India continues to regulate digital players through ex post uh, approach. So all, if Google and all these players, if they are indulging in any kind of abusive conduct, they can be hauled up, and they are being hauled up because Competition Commission has since established Data Management Unit DMU in its so in order to build its capacity to deal with digital players.
Okay, Dhananda sir, your last word.
Pavanji, I would only say that a time has come now. It's not the initial period. Then people are supposed to be knowing the existence of the competition law. The ignorance is not an excuse right now. So they must conduct a compliance program. There is a compliance kit available with CCI, but you can design. We can all help you in designing. Your clients can avail of that. They should conduct compliance programs for the officials, for the purchase and sale officials, also for the board members. There should be compliance program. People should be sensitized that they should know immediately, and whenever there is a new person who is inducted in the company, then he should be made to sign along with the appointment papers, that he has read the compliance program and he will abide by it.
Okay, okay. So thank you very much, sir. It's a time to close. Before closing, I just want to conclude this session. The competition law, as we have seen today, we have discussed with the experts. Competition law ultimately about market character. I think this is one biggest takeaway of the program. It is not the law only, it is character and it's a psychology of the business. It tests how a company behave when it's gaining power. So when you got power, are you in your command of things or you are becoming unbearable? How you price, how you contract, how you expand and how you treat competitor. In fast growing market like India, scales come quickly. Data accumulates quickly. Market shares shift rapidly. But regulatory attention moves just as fast. So the real issue is not always intentional wrongdoing. It is strategic overconfidence. Assuming the commercial success automatically justify every business practice. So friends, today when we have discussed this issue, collaboration must not become coordination, strategy must not become exclusion, innovation must not become suppression of competition. Board must ask one disciplined question before taking any major decision in the company. If the decision is examined by regulator tomorrow, can we defend its market impact? That is most important. That single question change behavior and everybody will say what is good, what is bad. India enforcement landscape is maturing, increasing. Digital market are under the lens. Global standard are influencing local actions and the era of passive compliance is over now. So you can't sit on certain things. Responsible competitor is not anti-growth. It is foundation of durable growth. Sustainability companies are not those that empower market. They are those that win within the rules. So I thank all my distinguished speakers, panelists, and my participant that you have given a new knowledge, new dimension, and everybody got enrichment for this from this dialogue. So let us compete hard, but compete fairly. That is the message we should follow. Thank you very much. Thanks to my all panelists. Friends, this journey of knowledge sharing will continue. 6 March, our next webinar will be on because income tax law is implementing on 1st April 2026. So 6, we are discussing on what are the changes in income tax law, the direct tax code which has come, what are the changes it has come and what are the things you have to now manage in this particular year when you finalizing your corporate income, your personal income. Till then, thank you very much.